a lot of people say, I want to be a trial lawyer. And that's a worthy goal. The question is, outside of the time you're spending at work, what are you doing to build your skills and craft? Because look, I'm not a natural trial lawyer. I'm not a natural speaker. I'm awkward and I embrace all that, but I have to practice. And the question is, what do I do on any given day, whether it's, at the office taking depositions or doing something else that helps me with my advocacy skills or helps me become a better persuader of jury and other people.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I've been looking forward to sharing this conversation with Shahrad Milanfar. Shahrad is a trial attorney and mediator who has leveraged his defense and neutral experience to catapult himself and his plaintiff-side clients into stratospheric case results. We'll talk about a record-setting 8-figure elder abuse verdict, a tragic story involving a catastrophically unprepared nursing home, and a wildfire. Shahrad's practice includes personal injury, police brutality, and wrongful death cases. He also has a family practice, and that's a play on words, in that he runs his office along with his spouse. She held a leadership role with a 900-lawyer law firm before running the Milanfar Law Firm. Like many modern trial lawyers, Shahrad developed initial trial skills serving the community as a district attorney before transitioning to civil work. A passion for trial work and technology has led to Shahrad teaching at the National Institute for Trial Advocacy, developing his own course using iPads in trial, and serving as an adjunct professor at Golden Gate University Law School. So please sit back and enjoy this deep dive with the multi-talented trial lawyer, Shahrad Milanfar. Welcome to the show, Shahrad.
Thanks for having me. Really appreciate it.
I wanted to start out asking if it would be okay to go into a little bit of your background and where you grew up. And part of that is because I think that may inform some of your decisions as you move forward.
So I was born in Iran, Tehran, and lived there during the Iranian Revolution, part of the Iran-Iraq War. So my dad was a colonel in the Iranian army, and we eventually had to move out of Iran in stages and come to the United States. So that obviously impacted me greatly in terms of my outlook and, living in Oakland after coming here and, how that formed my character and my approach to life. And I always say, kind of the grit that I try to live my life with because of those experiences and coming here and having to adapt and seeing how my parents had to adapt from going from here to here. And, my dad really, struggling to find a job and my mom working as hard as she did to make us have a life and being able to survive that to get to where we are now.
Did that inform any of your decision-making as far as having an interest in being a lawyer?
Yes, there's a particular event that's a direct correlation to us sitting here today, and that is growing up in Oakland. I was one of, very few kids that was Iranian in that school district, and I got my butt kicked several times growing up in Oakland. And I actually one time had to go and testify in court. While I didn't end up actually taking the stand, the DA in that case was very protective of me as a kid. And I think I was in like 8th or 9th grade. And the PD, for some reason, just was not a very nice person. So I remember distinctly leaving that courthouse in downtown Oakland and thinking, I want to be like that lawyer. And that's what sparked my interest in trial law and being an attorney. And that's kind of what I followed. It's one of those random acts that occurred that, impacted the rest of my career and life for that matter.
Let's follow that thread. How did that then show up in terms of your path through college? Where did you end up going to law school? And what work did you find yourself doing afterwards?
So I ended up going to undergrad at UC Santa Cruz, and then I eventually ended up at Golden Gate University Law School. So I wasn't a very good student, so I went to what people consider a third-tier law school. But the saving grace was that the head of the litigation department there was my mentor, Bernie Siegel, who was a famous criminal defense lawyer. So if you look at my transcript in law school, didn't do too well in many of my classes, but litigation, evidence, I was on the mock trial team. We did well. We won some competitions, and that really kind of fueled me. And I originally thought I was going to go be a prosecutor. But that didn't end up coming to fruition, because once I actually worked at a prosecutor's office and realized the politics that goes on, and that, quite frankly, I wasn't comfortable, putting somebody who's a minority away when the friend of somebody who was politically connected, they would say, well, you can dismiss that case. No, not going to do that. So I decided to go away from that path and then try to figure out what I was going to do.
To be clear, you did spend a little time in the prosecutor's office.
I literally worked for a year, saved all my money, and then went and volunteered at the prosecutor's office for 6 months because I wanted to build my backbone in standing in that courtroom and taking the heat from the opposing lawyer and the judges, and to be able to really have a good presence when I was in the courtroom. And, having gone to Golden Gate Law School, we would actually practice at Bryan Street for our mock trials programs. So I was familiar with those courtrooms, had been in there, hundreds and hundreds of hours. And this was just kind of building on top of that and being in that courtroom, because I knew as a civil lawyer, there's no way you were going to be in the courtroom as much as a prosecutor. But that, I thought, was going to be a path into the prosecutor's office. But at the end of that stint, I realized maybe this isn't what I want to do, because it doesn't line up with my moral compass.
So what came next?
What came next was I actually interviewed with a bunch of different firms, and I ended up taking a case at a defense firm and did that for a year, worked incredibly hard, and realized this was not the place I wanted to work at. Ironically, a public defender who I'd gone against in the DA's office ran into me at a deposition and said, hey, my firm is actually hiring. Do you want to come check it out? And I was looking for a job. So I interviewed with them and switched to that firm and ended up being there for about 19 years after I joined them.
These are the types of things that people oftentimes can look up at LinkedIn and other places. Are you comfortable using firm names?
Absolutely. I was with Becker, Cannon, Schweitzer for 19 years.
That's a long time.
It is. It is a long time.
I'm trying to figure out a good way to dig into that 19-year experience. And I guess one way of doing that is to touch on the comment about enjoying trial work. Not a lot of people get out to trial anymore.
Correct.
How did you find your way to becoming the effective trial attorney that you are now in that kind of an environment?
One of the practice areas that firm had was asbestos litigation. So I would go to a deposition. There's 20 lawyers there, and somebody has to take lead and ask questions of the witness, usually the plaintiff. And these depositions go for days, and nobody wanted to do it. So what I figured out was, well, this is practice, right? If you're a baseball player, you need batting practice. So I would sit there and I would basically ask questions, and you're going through somebody's life, really. And I was genuinely curious about who this person is as a human being and how they're going to be in trial and how they would present. And so I would ask questions, but my goal was that every time I finished a job site, I would turn to the rest of the lawyers in the room and say, any follow-up? And I would want to hear nothing, right? And there were times where these deposition was on the phone. So if I'm asking questions over the phone, I would have like a standing desk and I would stand up and I would practice. So from a practical standpoint, I have hundreds, if not over 1,000 days of deposition, right? I've been in and I've asked questions in as practice, as refining your craft, as opposed to sitting in my office and scratching my head and wondering when I could be a lawyer, right? Because a lot of people say, I want to be a trial lawyer. And that's a worthy goal. The question is, outside of the time you're spending at work, what are you doing to build your skills and craft? Because look, I'm not a natural trial lawyer. I'm not a natural speaker. I'm awkward and I embrace all that, but I have to practice. And the question is, what do I do on any given day, whether it's, at the office taking depositions or doing something else that helps me with my advocacy skills or helps me become a better persuader of jury and other people.
You bring up two things that I'm interested in following down rabbit holes as far as that's concerned. One is the clarity of self. And what I mean by that is, I don't know as a younger lawyer that I would feel comfortable saying to myself, let alone saying in a podcast setting that I'm awkward or I'm not a natural trial lawyer. At what point did you become, in essence, self-aware or comfortable with that as a concept? Or have you always been that way? Is it learning that you've done along the way?
Not at all, right? Because of my life experiences and the uncertainties that my life has, I was always very much comfortable with fading into the background. Like I would walk into a room and I would not introduce anyone. And as I kind of developed in my practice and my personal life, I realized this was self-imposed. That the more comfortable I was in my own skin, the more likely people were to be curious about who I am as a human being and what I can do in terms of professionally. So that was a really huge wake-up call for me that, we talked about before is, when I would come to a setting like this, I'd be like, does Miles like me? What are his opinions of me? When in reality, again, as long as my moral compass is set in the right direction and I'm doing things to improve every day, then that helps me essentially be who I am. And it's a lot less exhausting being yourself than it is trying to be somebody else. But look, at the end of the day, when you look at these incredible trial lawyers that you've had on your podcast, everybody wants to look at the result. And at the very end of it is, I want to be so-and-so. Put an amazing trial lawyer's name in that sentence. But nobody wants to look at the incredible amount of hard work that they did to get to that point. Just like the Olympics. I watched the Olympics and it's like, oh, she didn't land that jump. Well, I'm sitting on my couch, right? I'm not there at 4 a.m. when, Simone Biles is practicing. And that's, I think, the important perspective to have is I don't have a sense of entitlement in that regard. I know that today I'm not as good a trial lawyer as I will be next week. And that's, I think, what helps me kind of propel myself forward and to change my approach in a way that allows me to be better every time I show up for one of my clients.
So for those who struggle, and I'll include myself in this department, there's a phrase in a book that I've been listening to recently. He calls it FOPO, fear of people's opinions. And it talks a lot about just how crippling it is when you go into a crowded room. And this is something that I have to this day. Go into a crowded room with a bunch of my peers, and my sense is I'm not worthy. I'd love to hear a little bit more about how you kind of overcame that as far as that's concerned.
I don't necessarily think of it as overcoming it, right? Because all of us know, every high achiever I know has an imposter syndrome sitting in the back of their head. And that to me is a motivator. So you can use it as fuel or you can use it as headwind. And we have the ability to make that choice. So I remember, I always give a shout out to a good friend of mine named Marty Hawkins. And his kids and my daughter went to the same school, and they'd moved in from out of state, and my daughter was new to the school. So we went to an orientation, and I'm sitting there. The room is packed. There's one seat just kind of like where you're sitting across from me. And I'm not talking to anybody. I'm not talking to the person next to me. I didn't even acknowledge them. I kind of sat down and looked down and, I'm just like, get me out of here. Right. And Marty walks in. Marty's a tall guy. He's probably 6'4". And he walks in, he looks me dead in the eye and he says, "Hi, I'm Marty Hawkins," and puts his hand out. And I tell them that that's when the switch flipped for me. Like, you don't have to be, the same color as the wallpaper or the paint on the wall. You can be yourself and be comfortable that if I say, hi, I'm Shahrad Milanfar, and you choose not to shake my hand, it's not about me. It's about you. Because if you were to switch me out for the next 100 people, you would do the same thing to them. And once I divorced myself from this idea of like everybody has to like me, then that really helped me open up and take risks that I never would have taken before that event occurred. And I credit Marty for that because he didn't intend it, but that was a lesson that I took away just by that one interaction that we had.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. As we work through your defense background experience, one of the things I'm curious about is your work with adjusters and your ability to not have your name associated with a bunch of nuclear or thermonuclear verdicts on the defense side. And just so we have some reference points, I believe in the industry, nuclear is $1 million and thermonuclear is 10 million, right?
Yeah, I think so.
Okay. That's what I've heard anyway.
Okay.
And so how is it that you managed to work with the plaintiffs' lawyers that you've been dealing with and with the adjusters to make sure that your risk assessment was being listened to and not throwing you into a situation where, a top flight plaintiff's lawyer has got you in the gun sights?
When I was in my old firm, we represented auto manufacturers, tire manufacturers. So we had, firms like yours and other prestigious law firms who have gotten massive, massive verdicts constantly in our cases, right? So for us, it was a matter of looking at it and being human about how we viewed the cases and not losing sight of that. And we basically gave advice regardless of how it was going to be received on the other end, because in my opinion, my integrity is not for purchase, right? And if you come to me as an insurance carrier and you're asking for advice and our honest opinions on a case, I'd rather tell you my honest opinion and never work for you again, as opposed to when we're looking at a $30 or $100 million verdict down the road. So in that sense, part of having your spine or your backbone in this industry is being able to provide information that's not necessarily wanted on the other side in a way so that they can actually be receptive to at least hearing a different perspective, right? Because there is a lot of incredibly talented and wonderful adjusters that I've worked with over my career, but there are some who just don't necessarily get the big picture because their training tells them every case is garbage and we shouldn't pay on any case. And that's okay. But if you want to put the other side in a courtroom, don't complain later about how that event turned out if you didn't listen to your own counsel. And that's the way, we tried to approach it is, look, this is the such and such firm. These are their results. This is their client. This person is going to come across as a wonderful human being. By the way, during the last 2.5 to 3 years, they haven't sat around twiddling their thumb, feeling sorry for themselves. This person is actually trying to learn how to walk again. And that's something as a human being I look at and say, this person isn't looking for a handout. They are actually looking for something that's going to put them, somewhere toward where they may have been before, even though the money is never going to change the physical impact that, has been had on them because of what happened.
I don't want to, in essence, bury the lead in terms of some of the other things we're going to be talking about in terms of your plaintiff side work.
Sure.
Meaning, as people are listening along, that around January 2020, an interesting time. You pivoted into doing primarily plaintiff side.
Correct.
And we'll go there. While we're here on the defense side, though, in terms of your chronology, one of the questions I love asking people who've had that background are, what are common pitfalls that you have found on the defense side that plaintiffs' lawyers are failing to do in terms of either making your job harder or making the adjuster more hardline? What things can plaintiffs' lawyers do to make it easier for defense lawyers to help them resolve the case?
I think I heard some of your previous guests talk about this concept as well, and I wholeheartedly agree, is that transparency is not a bad thing. There's a concept in a book that I read that's bury your neck. Just expose your neck, right? And in a fight, you never want to do that, right? Because of the danger that it brings. But if your case is truly a good case and you have some great evidence and you really think it's the best thing for your client to resolve the case before trial, don't hide anything. What I try to do is to just give the other side as much information as possible. Why? Because that defense attorney is taking the information and doing reporting, right? They have to do regular reporting. And those reports go in the adjuster's file. They look at it, and then the adjuster does a report and they committee it. So if you've got some damning piece of evidence that you're hiding, that's a problem, because you're preventing the case from resolving.
Oh, but if I save it for trial, they will just be so surprised and the verdict will be so huge.
Absolutely. The question you have to ask yourselves is that in the best interest of your client? Because while my ego is satisfied so I can walk around and say, I got this massive verdict, yes, it's amazing, it feels great, but is that the best thing for the client if that case goes off the rails and the jury doesn't go your way? So that's really the biggest thing, is as an advocate, my primary obligation is to resolve the case. And I've had, on the defense side, plaintiffs' lawyers where I've called them 10 times, hey, you want to resolve the case? I got settlement authority. I don't hear back from them. And that's puzzling to me on two fronts. One is you have an ethical obligation to your client to pick up that call and respond. And two, don't you like making money? Like, don't you have overhead that you have to pay? And that always puzzled me, because I look at it as this is available and there's somebody on the other side giving you this opportunity to resolve the case and you're not wanting to do it. And the perception is that the case is going to have more value down the road. But how do you know how much authority I have unless you engage me in that conversation?
That shifts me into another area where you have spent some time, and you've spent time as a mediator, correct?
Correct.
And before I ask my question, can you just kind of give an outline of how you ended up in that field and why you ended up in that field?
My wife and I bought a house in the early 2000s, and it turned out that the broker and the seller both lied about a major flooding problem. 20 days into it, it was around New Year's, and I hear this massive bang outside our house. I run down to check on our daughter, and I almost slip and hit my head on the ground. Turns out that the patio had filled up with water, and it was just flooding into the home. Well, wow. As you know, unless you have flood insurance, which we didn't have because the house wasn't in a flood zone, you are stuck footing the bill on that. So we ended up having to sue the broker and the prior owner, and we went to mediation. Wonderful mediator, just not a very good one, indicated to me that you're a lawyer, therefore, essentially, I should have known that they were lying to me about this flooding problem, and I should take this amount of money that was going to bankrupt my family. And my response to him was, if there's anybody who can try this case, it's me. If I'm going to go bankrupt, I want to take all these people with me. So that really got me thinking that as an advocate, I'd been to hundreds of mediations, yet I did not understand the perspective of the plaintiff And so I decided I needed to learn more. And I started taking, classes. I took Steve Rosenberg's class, which is a wonderful mediation class.
Teach with that.
I did.
Right?
I have taught in his classes before. Then I basically volunteered with Center for Human Development, doing guardianship and neighborhood dispute mediations. And as you know, neighbor disputes, there was people threatening to kill each other, and we're able to get those resolved. So it really changed my perspective about how to persuade another human being to see different perspectives. Not to persuade them to see it my way, but just be open to it. And I think that experience allowed me to then become a more effective lawyer and have better relationships with opposing counsel. And it's been a fantastic experience. So I've done, I think, maybe 113 or 14 mediations as a mediator. And I always love it because if you do exclusively plaintiffs work, you never get up and go into the other room and see how that plays out. And as my kids remind me, singing is wonderful from here to here.
From your own mouth to your own ear. And I'm doing that.
For the audio.
I'm doing that so it's clear on the record.
Yes.
Go on, sorry.
But, the idea is that the words sound great from my mouth to my ears, but they might be insulting from my mouth to your ears. And that perspective has been really invaluable just as a trial lawyer of how do I persuade the jury to go into that jury room and be advocates of my perspective because they believe at their core that what we're advocating is the right approach.
So with that foundation, I want to return to the calling up the plaintiff's lawyers and saying, hey, I got settlement authority, and somebody not returning the call.
Right.
What I have come across, and I'll confess I'm a bit guilty of this myself. I grew up in the ADR era, which means a lot of the times I'm not as comfortable calling up the other side to discuss a case as I am calling up a mediator to say, hey, go discuss this case with them. Did you find that to be an impediment, both on defense cases and now on the plaintiff's cases that you're handling?
I have been fortunate enough to be able to settle the majority of my cases over the phone. And I find that the lawyers who are really comfortable in their own skin, we can call each other up and say, hey, Miles, you know what? Here are the things I disagree with you about this case, and disagree respectfully, as opposed to, hey, Miles, I'm going to kick your behind in trial. And when you're able to kind of back that up, again, I don't have a fear of going to trial. I selfishly want to go to trial. But what I do as a plaintiff's lawyer that I didn't find was common is to call the defense and say, hey, please, do you want to settle your case? Let's discuss settlement and let's get it done. And that is something that I feel people see as something they fear, like they're showing weakness by talking settlement. It's like, how?
Well, I think that some of us are hardwired, and I think it's a different approach to life, the universe, and everything, which is the expose your neck as you're talking about. That vulnerability can have power, which I think people are becoming more comfortable with these days. But for some of the older line pieces of it, older line lawyers, what you learned was, I'm going to kick your ass.
Absolutely. That has some value. But a lot of times, if you're looking at an insurance carrier, they have to see that this is valuable to them to resolve, right? And I'm going to kick your ass may have some value, but I usually don't worry about people who tell me they're going to kick my ass as much as the people like yourself who quietly go about doing the work that will result in my ass getting kicked. So to me, a lot of times, like when I'm in depositions and I'm asking questions and I'm getting objection after objection after objection, that tells me I'm doing something right. I don't take it personally. Thank you for objecting. It tells me I'm getting close to some gold right here. So in that context, you're right. There's a lot of old school or hardline lawyers who want to pound their chest. We're going to take you to trial. And I've had that experience with somebody who had probably 150 trials under his belt. And as a younger lawyer, I'm like, what's the drawback to that? If you take me to trial and you kick my behind, people will say, wow, you had the guts to go up against this guy. But if I kick your butt, I'm going to be a hero. So selfishly, you're not doing me a disservice by threatening to take me to trial. And this person's response was, wow, that's a good point.
Beware the quiet, calm, confident lawyer as opposed to the yell-in-your-face lawyer.
Absolutely.
Yeah.
Because they're wasting their energy yelling at you or calling you to threaten you when at the end of the day, if they're working, that's what I worry about, right? Posturing may impact the other side. The question is, are you doing it to put pressure on the other side and somehow scare them, or is there a true benefit to your client? Because again, if you think about it, if you and I have rapport together and we're on opposite sides, we can talk, we can disagree, and ultimately, at the end of this case, we can go and have a meal and, shake hands and be friendly or be friends down the road. But if it's all about, let me punch you in the face, are you really going to cut my client any slack when I need something? And let's be realistic. In litigation, everybody needs something at some point. You're going to need an extension. You're going to need a courtesy. And I tell opposing lawyers, even when we go out at a deposition, it's not personal, right? We're just being advocates and we're helping our clients. And if you keep that in mind, then the other lawyer doesn't become a companion in your head. And I find that if you are making me upset, the last thing I want to do is to give you permission to open up my head and climb in and be my companion for the next week, right? That real estate is not for rent or sale, in my opinion.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.